Good morning, everyone, and welcome back to day 2 of our course on IP management. I'm going to hand over straight to our first presenter for today, Patrick O'Brien from Spoon Fisher, who you met yesterday, and after the break this afternoon, Michaela Orlando will be taking over. Today, we're going to be delving deeper into quite a few of the issues that came up in questions yesterday. And yeah, hopefully we'll consolidate all the learning. A reminder that a link will be posted to an evaluation form at the end. So please do fill that in. That will be required if you want to receive a certificate of attendance and a copy of the slides. With that, I am going to hand over to Patrick. Thanks.
Thanks, Rosemary. From my side, welcome back this morning. I'm sure it's morning for most of us. So I'm going to share my presentation, just get straight into it. I'm going to start off just dealing with a practical scenario from the session I ended off with yesterday. I assume you can see my slides. Could I just get a thumbs up or a confirmation from anyone? Can you see the presentation?
Yes. Yes, there's some thumbs up going, so all good.
Oh, sorry, I missed those. Okay, thank you. So let's get cracking. So this is the scenario. We have an inventor who's a former researcher who has retained ties with the university. The invention was first contemplated while at the university, but the commercial potential was seen by the researcher afterwards. So realized after leave and starting his own company. The inventor is in the process of performing lab scale research in Botswana, establishing pilot plants which would become operational within the year, and looking for commercial phase production once the university involved for the research product development. So this is what the invention is. We have a commercial culture and processing of the African silk moth for silk production. The specific species is endemic to Southern Africa, and it feeds on a variety of plants found in the area. It's never been cultured at large scale before. It has huge agricultural potential. And the invention disclosure provides the following. So there's culturing of moths using specially designed enclosures. Those conditions and certain feeding regimes. And then we have the breeding of moths to produce a strain with a 20% yield increase. And the processing of the silk has that certain, so an EDT, a wash, regumming, and spinning. So the specific details aren't really necessary, but the important at the stage, but just to know that there's a processing of the silk is part of the invention disclosure. The prior art, so I discussed this yesterday. Remember, that's everything that comes before our priority date. So at this stage, there's no filing yet. So our priority date essentially is today. So everything that's come before today it could be relevant, and obviously we are looking at what is relevant. So it's a known species of moth. There are known silk moth enclosures and husbandry procedures. There's an academic publication which relates that demineralization enables reeling of silk moth, wild silk moth cocoons, and using EDTA. And then the research has published their own thesis relating to the application of Cathalite's method to African silk moth cocoons. So that Cathalite method is the degumming by Cathalite method. So this is practical, so I would appreciate some answers and feedback, and we can make this interactive. So I'm going to take us through these questions step by step, and yeah, we won't spend too much time on this. We'll get cracking with today's material, but yeah, just a bit of a refresher. So did I get an answer or two? What IP do you think is involved? Not sure if anyone has their hand up. I can see the chat.
Yes, everyone is taking a while to get centered this morning, but please feel free either to answer in the chat. Here's one answer in the chat, or raise your hand.
Okay, I see one person has suggested patents, another design of the enclosures. By design, do you mean a registered design, or do you mean something else by that? Olaf? Registered design, okay. Anything else? Okay. What do you think? I see Escutia, you've got your hand raised.
Yes. All right. I had to rear a few things myself in larger volumes. Nearly got shot by the military for it. But one of the things is that to take something which lives in nature and get it together in a larger volume brings a lot of issues. That part should be kept as a trade secret so that if somebody tries, they cannot reproduce the breeding and looking after them, because there's a lot of knowledge that goes into it, and you cannot really patent it. So you have to looking after the knowledge. To me, the patent is how to produce the silk and use the silk. But I definitely see trade secret in here.
Yeah, I agree with you. Thank you for that. So a couple of considerations. So we mentioned that the researcher has published one of the steps. So let's go back to the method. They've published this degumming by Cathalite method. So that step has been published. Okay. The prior art discloses EDTA wash and spinning using commercial silk spinning equipment. So clearly that forms part of the prior art. So from a patentability point of view, it appears that now we're not dealing yet with whether this is an invention or not. We're just dealing with whether this IP is novel. It appears that these steps altogether might be novel, but inventiveness is quite questionable because this step's been published. The first step has been published, and the last step is the commercial process. So it would be obvious to a person skilled in the field, perhaps, to combine these. If they've got the literature, they've got these two articles, they can put them together and find that we get a good processing of silk. So it's possible that a patent is out just from a novelty and inventiveness perspective. I see someone here in the chat has said breeders' rights. I'm not sure if you're referring to plant breeders' rights. That would relate to plants only. So this is not that. Okay, so the trade secret route, I think, is a very good option. But before I get there, just dealing again with patentability. So the Patents Act, and you would have, those of you who attended Kwingile's presentation on Wednesday will have heard that animals are not patentable. So you can't patent moths or breeding of these moths. So where I see something which is patentable, potentially, is the so there are known silk moth enclosures or husbandry procedures, but this specific conditions is what is the provides for this 20% increase in yield. So that is an option for patentability. So it's a method or a system, and it would include certain light, airflow, humidity conditions, certain feeding regimes, and that would be where your invention lies. Okay, but now remember, are we gonna patent it and disclose it, or are we gonna keep it a trade secret? Now, the very next section I'm going to go into, and I'm going to start off with today, is the interaction between patents and design. So I'll discuss it a bit more there. But that, just to answer that first question, that's perhaps two of the IP options that are involved and where.
All right,
so dealing with just novelty again, just to remind you, it must not be available to the public anywhere in the world in any form. So it's critical to maintain confidentiality. So this is a scenario where, unfortunately, there has been publication by the inventor himself and other stuff. And anywhere in the world implies anything which the public can gain access or knowledge to, and does not form part of confidential disclosures. So in research environments, it's essential to prevent any form of publication by researchers before patent applications are filed. And then that provisional application or priority application gives you that priority date. And that's the date at which you assess novelty and inventive step. But yeah, important to bear in mind that it may sometimes be beneficial, if possible, to retain the confidentiality of the invention until, if you're considering patentability, until a complete patent has been filed, because there may be a need to refile or make certain changes or developments, which, if you disclose in the meantime, could destroy the novelty. So, yeah, just some considerations. Okay, I've kind of answered the third question, which I think is the identifying the invention. I'm not going to touch on the second one. Patentability, I've dealt with those issues. Maybe I can get some answers to the last two bits. So do you think there are any cross-border issues? Do you think there's any other legislation which could be relevant that should be taken into account? And if you were to follow the patent route, what strategy would you suggest based on the discussion we had yesterday? It would be great if someone could put up their hand, and it's a bit complex maybe to just type it in the chat box, but let's get an answer or two. And remember, this is a discussion. There's no wrong answer. It's yeah. The purpose of this is to learn. Regina, thank you. I see you got your hand up.
Yes. I think I could attempt to tackle in regards to other legislation to consider, since there are aspects that have to deal with moths in the process of the reproduction of silk. I think the legislation that one has to consider would have to do with I don't know if pest control of some not pest control, some kind of, but like legislation that protects pests or animals in some regard, that kind of environmental legislation to consider, because I think, yes, it either has to do with the protection of the pests or animals and the environment as well, that their methodology is not a danger to the environment.
Yeah, I fully agree, and that's a great answer. It's definitely environmental legislative considerations to take into account. Anyone want to give the cross-border issues a go? I'm going to be discussing this again later today, but yeah, you're welcome to comment if you think that there are any possible cross-border issues. Anton?
Hi, morning. Mine is really a question, not an answer. In a chemical formulation, that is patentable. In this scenario, you're taking environmental conditions and you're actually also having a formula. It's a formula that'll give you the right amount of humidity, the right amount of temperature, etc. So
Yes.
is that formulation then not patentable?
Yes, so we refer to that as a system or a method, but it's actually a good analogy that you draw. So thank you for that. But yes, so the method and the system involving those elements that could absolutely be patentable. Anyone want to comment on cross-border issues or patent strategies?
Was somebody talking? Sorry.
All right. One of the things is depends where you set it up. If you can set it up in an area where it occurs naturally, you don't have a problem, because the moth occurs basically in the dry areas of not only Botswana but also South Africa and even up north, like up to Central Africa. So if you set it up, your factory, in an area where it's naturally occurring, you don't have to get the moth from Botswana because the moth already occurs naturally in South Africa.
Okay. There was someone else also? Yeah.
Yes, I was going to
Yes.
say, I'm now thinking ahead, but in the commercialization phase, I'm considering taxes as well.
Yeah. Yeah, absolutely. And cross-border. That's cool. So cross-border issues in relation to the IP itself. So not other legislative
Not the
measures, but the IP. Olaf?
Okay.
Aren't there some biodiversity legislations that need to be possibly considered?
Yeah, it's very likely, and that would fall sort of under the environmental consideration. So, yeah, there could be. In the interest of time, I'll just give you my sort of thoughts. So, cross-border issues. First of all, it doesn't say here where the university was, but let's, for argument's sake, say that the university was based in South Africa. So the invention was derived while the inventor was a student or researcher at the university in South Africa. So in terms of the university's IP policy, in terms of South African legislation, the invention belongs to the university. If they want to set up their own company and operate in Botswana as a starting point, first of all, the exercise of the IP in Botswana, let's say that there was a patent there, that would be a cross-border transaction, obviously, because it's two different territories. two different jurisdictions. So that's one thing to consider is there a requirement for exchange control approval? Who owns it? Do you require assignments between the university and the researcher's startup company? And the answer is yes, you would. Of course, if that was then based in Botswana, if the startup company was registered in Botswana, if there were an assignment out of South Africa into Botswana, you would require exchange control approval. I do speak under correction regarding exchange control. I think for the common monetary area, there might be exceptions. But let's say that aside for now. It's let's say it was a different country and maybe a different continent. The principle really is that there's cross-border transaction and you would require exchange control. And then a patent strategy, well, that really depends on your commercial interests. So are you going to be operating in Botswana only? Are you going to be operating elsewhere in Africa? Are you going to be operating in South Africa? And I can't remember whose comment, if it was Anton or someone else's, but the comment about, the climate is probably quite a relevant factor. Obviously, you're setting up an enclosed and controlled environment, but if your external environment is already quite suitable, that makes your operation more economical because you don't necessarily need to expend as much money on humidity control or temperature control or importing feed or whatever the case might be. But so those sort of factors might determine where you are going to be commercializing. And then that informs where you're going to be filing your patents. There's no use filing a patent in a country where there's no commercial value for it. So I always use the example of mining. If you develop a mining invention for, let's say it's relevant to copper leaching, whatever, you're not going to be filing that patent in a country where there's no copper mining because there's no commercial. And even if you're not excising it yourself, there's no one to license it to. There's no one to stop because there's no commercialization of that technology in that country. So you would be throwing your money away. So where you're going to commercialize informs where you're going to be filing. And so if you're going to be filing locally, maybe start off with the African provisional application or a Botswana provisional application. And then if you maybe want to move further into Africa, you can consider the repo filing system, or if there are other countries which have similar climates or commercial value, maybe in Europe, maybe like somewhere like Spain or something, then you want to consider, well, maybe I should go the PCT route. It could be more economical, or perhaps just go straight into the European Patent Convention. There's a huge number of options, but your filing is based on your commercial strategy and interests. Okay, I'm going to move right along. Okay, dealing with patents and trade secrets. So what are the differences between the two? So patents, we know, has a maximum term of 20 years. A trade secret could, and emphasis on the could, have an indefinite maximum term, which means it can go in perpetuity. Let's look at the Coca-Cola recipe, which Nikki mentioned yesterday. As long as you can keep it a secret, you retain the value, and you could commercial or gain economic value from that, for as long as you are around. Patents protect inventions specifically, but trade secrets could extend beyond just an invention. So something which might otherwise be patentable. You could have trade secrets which could be or confidential information which has value in the form of a registry of suppliers for certain materials. And that could have value because it's not easy to gain access to that. Let's say it's maybe in an obscure country somewhere in Africa or somewhere in Asia, there's commercial opportunity, but an outsider won't know, well, who do I contact? Who is this reliable supplier? So that database could have value, and that could itself be a trade secret, which could be licensed. Patents are registered, trademarks are unregistered, and they're unregistered purely because if they were registered, they would become publicly available and no longer confidential. There are, as we discussed yesterday, high registration costs for patents, but for designs, for trade secrets, there are no registration costs, of course, but you may have high costs to keep that information secure, as we discussed yesterday, and often do. And for a patent, you have to disclose the invention in detail, and then upon expiry, that information falls into the public domain. So that's the quid pro quo. Government says, okay, you've got 20 years for this monopoly. You pay for that, but then the other side of that is that your invention then becomes publicly accessible and available, and that also promotes research, it promotes further innovation. So that's the quid pro quo of a patent. And a trade secret, of course, is, as I said, it must be kept secret. It's in the name. So subject matter of trademarks, trade secrets is undisclosed information, could be any technical or business information. It has commercial value. That really is. You know, you could have a trade secret for, I don't know, the way in which you feed your pets at home, but there's no commercial value in that. So it really it falls around the commercial value of it. It provides you with a competitive advantage over your competition, and you're able to. It really is secret because it's subjected to reasonable measures of keeping it secret. So it must be. You can't have a trade secret which can't be kept a secret, and I'll touch now on what that means. So yeah, I mentioned Coca-Cola's formula as a recipe of that. There could be things like clinical trials as well, or other recipes. You know, KFC's herbs and spice recipe. Could be undisclosed research findings. In any field of science and technology. And it really, trade secrets have a scope broader than that of patents. And it may be used to protect matter that cannot be protected by patents. So I'd like to ask you this question. It would be great if I can get an answer to, but patent or trade secret, what do you think the determining factors are which guide whether to follow trade secret route or the patent route? Let's say it's an invention which is patentable. So those factors aside, it can be patented and it can be, or rather, let me put it this way, it can be patented. Now you must decide, are you going to patent it or are you going to keep it a trade secret? What do you think is the most important factor to consider and which is going to guide that decision? Yes, Kutsia. I think you are still muted, so.
I'll say, haha. Okay, that one is easy. If you use it, can you copy it easily? That's a patent. If you use it, does it disclose what I've done? Like eating KFC, it does not disclose the spices, by eating it, by using it, by consuming it. But if I have a new tire, by using the tire and dissecting the tire, you can reproduce the tire. Then you need a patent to protect it.
You are spot on there. So can it be reverse engineered? If it can, go the patent route, because then you have a definitive scope of your protection. You get 20 years, and 20 years is a long time. You can establish a market in 20 years and dominate that market. It might fall into the public domain after that, but you have a 20-year head start on anyone else. And who knows, it depends on the technology. Maybe it's actually in 20 years' time, the invention is irrelevant in any event. So whether or not it's a trade secret doesn't matter because it no longer has commercial value. So can it be reverse engineered? Yes, file a patent. If it can't be reverse engineered, if you have some secret method of producing a polymer which has very advantageous properties, and you sell that polymer on the market, someone can buy the polymer and say, okay, well, yeah, look, it's polyethylene, but it has such a unique structure and strength properties, and this, how do I actually manufacture this? That process is a trade secret, and it can't be reverse engineered. You can't take that product and go and see how it was produced. So, so that's also a great example of where patents and trademarks can coexist, and that's my next point. You could have a patent for the polymer you've produced, but you keep the method of production a trade secret. And so you've got 20 years, no one else can sell the polymer, but you don't tell anyone how you produce the polymer. You obviously disclose the polymer and the composition of the polymer and the materials and sort of characteristics of it, but you can then keep the manufacturing process a secret and monetize that for as long as there's commercial value in that product. So they can coexist, and that's really important to know. By the way, I haven't actually referred to this term know-how, but that's you would have come across that. And know-how, trade secrets are the same thing. Confidential information is related, but and obviously trade secrets and know-how must be confidential. But confidential information could comprise other things which you wouldn't necessarily consider those as trade secrets. Patents are essentially born as trade secrets because once you've developed it, before you filed it, before you've disclosed it, it is a trade secret. And very often in your development and innovation, trade secrets follow patents. So you have a new invention. It could be reverse engineered, so you decide to patent it. And then in the process of commercialization and further development, you find, but actually there's a unique aspect you could add to that, which adds a whole lot of value and isn't reverse engineerable, and that could be the subject of a trade secret. So, yeah, and that just being dealing with commercialization, those sorts of things increase the value of your patent licenses, and although the patent will expire at a certain point, the trade secret can go on, and you could keep that as the subject of your licenses and retain that revenue stream. Okay, so just practically, how do you retain secrecy? So I mean, there's just some examples, and obviously it depends on what the form of the trade secret is, but label documents, use NDAs when dealing with third parties. It might sound obvious, but lock your gates and cabinets, and that kind of applies digitally as well. Lock your server, keep access restricted, have agreements in place with employees. And just again, whether you're in an academic environment or private industry, educating your employees on the importance of trade secrets and other IPRs is critical. They might unknowingly and unwittingly disclose trade secrets and not realizing the value thereof. So education within your institution is always important. And then if there is disclosure, early disclosure of some of your trade secrets does not mean all is lost. If you act swiftly, you can limit damage, but you must be prepared to enforce and quickly. So obtaining urgent courts interdicts, whatever the case might be. We dealt with a matter for a big client a couple of years ago, and a big mining company, and one of their researchers was also in public research space before and subsequent to various universities. And when he left the mining company, he's of the view that research and information should just be disseminated for the world to see and know, not understanding the incredible amount of resources that goes into obtaining and developing that trade secret information. And so he took some of that data with him and published it in some of his academic journals. And so our clients had to act swiftly, limit the damage, get the data that was disclosed online in various journals, get that removed by the journals, and ultimately just limit the damage. So you can't undo what has been done, and some people might have already seen some of that data, but you could still limit that damage, and perhaps have it be really minimal if you're able to act soon enough. Okay, so that situation I referred to now, that then comes into the realm of competition law, and we're dealing here with private competition law, which is it's known as unlawful or unfair competition. So it's not the same thing as anti-competitive behavior, which is public competition law, and that's governed by the Competition Act. Unlawful or unfair competition is governed by the common law. In other words, it's governed by case law, and there's a wealth of case law in South Africa, but across the world, really relating to what is unlawful or unfair competition. A term you might have heard before is springboarding, so that it kind of is a great analogy. You taking someone else's IP, and you using that, they've built a springboard, and now you're able to jump higher using their springboard, which is of course unfair and unlawful. And a term you might have heard of is misappropriation of confidential information. So it really is theft, it's stealing. And so trade secrets or confidential information is property, it's intellectual property like any other property. So misappropriation, it's theft. So that's any act or practice done in the course of industrial commercial activities that results in obtaining, using, or disclosing to third parties undisclosed information without the consent of the rightful holder of that information. So the use of or the disclosure of a trade secret to another person to use, or the violation of a duty to maintain confidentiality. So it's as much as you could actively misuse that information, if you're obliged to keep it confidential and you don't take the required measures to keep it confidential, you're also guilty of this. So acquisition by improper means is things like theft, bribery, espionage, breach of inducement, or someone else's breach of their duty to maintain confidentiality. And if you obtain it by that means, it's still an improper means, and you're guilty of unlawful competition. But if you were to independently discover or reverse engineer or just discover from observation, then that's not misappropriation of a trade secret. The fact that you independently arrive at someone else's without access to their information or data, that's not unlawful. That's not unfair. And that's again the importance of, well, can it be reverse engineered? And if it can, well, it's not really a trade secret, and you can't claim misappropriation of a trade secret, which is acquired by proper means. You know, if it's reverse engineered, for example. So that's it for patents and trade secrets. Are there any questions before I move on to the next section? I see there's a couple in the chat. Yeah, Divine makes a comment that patents is the most important. Much as the process will take long, it will secure the IP rights. Trade secrets, once leaked, you lose out. So you are correct that if your trade secret it becomes public knowledge, then it loses its value, and that's correct. But if you are able to keep it secure, then it has more value if it can't be reverse engineered. Yeah. When attached public. Sorry, I'm not sure, Mauro, Ricardo, I don't understand your question. Do you perhaps want to elaborate? Okay, I'm going to move on to the next question. How effective is enforcement of restraint of trade within the trade secret paradigm? Yeah, so restraint of trade is different to trade secrets. Restraints of trade is my technical expertise. A trade secret is independent of me. That's the IP. So the fact that I know how to do it doesn't mean that I get to do it if that trade secret belongs to someone else. So just to sort of differentiate those terms. With lapses in professional integrity, have there been instances where trade secrets have been disclosed? So yes, that was the example that I just gave now. It does happen. Advocate Nosipo, I see you have your hand raised.
Thank you very much. I am aware that they are different, but I'm looking at the the relationship between them. The restraint of trade is about you having acquired expertise that is part of that particular institution within which you would have some trade secrets being battled. That's why I'm saying, how do you extricate the two? For example, if you are working at CSIR and say you want to you are let's say you are an outer space engineer, right? You've developed a capability there, but this capability that you've developed it using the information that is a trade secret of a military. Okay, I'm trying to pull them together so that you can understand what I'm asking, right?
Yes.
Because there are trade secrets. There are trade secrets that are a function of that particular sector, and there is the you as a person who has been there, who has acquired the skill and the training, and then there are the labor relations issues that are involved. How do we extricate the two? That's my question.
Yeah, I mean it's not black and white, obviously. Yeah, or maybe not obviously, but it's yeah. So it comes down to what the trade secret is. If you are not authorized or entitled to take that with you, you can't. Let's say it's a certain process or a method of doing something. You can't go to your new employer and do that as a trade secret. But your expertise, your ability to be a space engineer or whatever the case is, that you can't take away from someone, and they need to have a livelihood as well. So restraints of trade is limited. You can't enforce that really beyond, in South Africa at least, like 6 to 12 months. You're not going to be able to enforce it because that will start becoming unconstitutional and various other factors coming. So there's not necessarily always a defined separation between what your trade skill is that you've acquired and the trade secrets that you've acquired it from. But the commercializable interest, the trade secrets, you can't infringe on that. Okay, I'm going to move on to IP and contracts. Okay, so developing joint R&D contracts, so research and development, that happens where both parties invest their resources, skills, or assets. They jointly define the objectives, timelines, ownership, access, publication, benefit sharing, confidentiality, appointment of a lead office. So if there's joint, maybe it's 2 entities or even more that come together, it's best to appoint one of them as the lead office for decision making, perhaps in terms of IP strategy or providing instructions to IP attorneys, so that you're not having instructions coming from 2 different people. And often when you're dealing with maybe further commercialization or investment, investors often want to deal with one person. They don't want to have 2 companies that they have to deal with. So it really is that you appoint one lead. Obviously, the decision making then happens internally. View that sort of joint venture as a single entity for those purposes. And from the outside, it's kind of viewed as one. But the entities, of course, do remain separate jurisdictional entities. And then, obviously, you will have a steering committee which will review decision making and that sort of thing. So some of the clauses relevant to IP in a research contract. So firstly, deal with the scope of the contract. Have your recitals, say which party is doing what, who comes with what, understand the positions of the parties, understand the aims and the objectives, what the needs are and expectations, and that really governs the rest of the contract. Confidentiality, so very, very important. Clauses for IP or for contracts in general, but research contracts specifically. And parties enter into research contracts with the aim of creating some new and useful information that can be based on previous or existing information. And you want to keep the existing or the new information possibly separate from what came before. So the interests of the parties you're looking at is that maintaining a strategic advantage, withholding business information from the public. And you need to look at the duration of the confidentiality. So it will be for the term of the contract plus some period of time. You can't establish that there's a requirement of confidentiality indefinitely, because it is unreasonable. So you can't say for 100 years. but you could provide some reasonable term, and that term will maybe be informed by the technology that you're dealing with. Obviously, it's confidentiality is mutually applicable, so it goes both ways. Both parties will be sharing their own confidential background information, and the other parties will need to respect that. And there's a difference between an NDA and a confidentiality clause in a contract. So an NDA precedes contract negotiations. That's where you need to share confidential information in order to establish a relationship, in order to attract investors, whatever the case might be. And obviously a contract deals with the information received during the term of the contract. What cannot be confidential? So information which is already in the public domain, you can't state that as confidential. Something which was in the recipient's possession before the disclosure by the person disclosing. So not necessarily before the contract, but just before the disclosure. So even if the disclosure happened before the contract, you can't maintain something as confidential which was independently developed by the recipient or is received from a third party who was entitled to disclose it for whatever reason. And then certain information can't be held as confidential by operation of law or a court order requiring that it be disclosed. And then, yeah, you should just mark confidential information as such, where it's possible to do that. So as we know, especially for research institutions, there's a trade-off between confidentiality and publication. Universities are responsible for publishing their information and results for the benefit of the public and as a performance metric. But if agreed to, the confidential information must be treated as such. So this was the scenario I gave you earlier of our client. Despite agreements to keep the data confidential, and even if he himself had obtained the data through studies, it didn't belong to him and he was required to keep it confidential, notwithstanding that it might have been a research environment. Publication of the information must be cleared by the other party ahead of time. And in fact, this was this person had sought clearance from our client and it had been denied, but notwithstanding that, he went ahead and published. So yeah, that it is a major risk of breach of contract, of course. So background IP is what an organization already has in its possession and what is currently under development. It may include know-how, teaching material, software, for example. Be careful when you are negotiating contracts. Be cautious of reach-through clauses, which essentially provides that the other party can obtain royalties for any development that you do independently of them, going forward using their background information. So yeah, there's sort of a limit to maybe what you'll allow or not allow, and of course the circumstances will dictate exactly whether you will or the extent to which you will provide for reach-through clauses. The foreground IP is where it's created during the collaboration between the parties. So I spoke yesterday of inventorship is a starting point for ownership. So who are the inventors dictates who are the owners. The implications are that you can't deny rights or falsely award them. So if another party has an inventor who works for them, you can't deny that party rights because they are entitled to it as a result of the fact that the inventor is an employee of theirs. Or you can't falsely award it, where we're not. So it must be jointly owned in the first instance if there is joint inventorship. But of course, you can then agree to the division of ownership thereafter, and that could be whether You are co-applicants, let's say for patents, you are co-applicants in every country where you commercialize. Alternatively, you could say, well, my market is Africa, your market is Europe. So I will be the owner for all the patents in Africa, you will be the owner for all the patents in Europe. Just as an example, there's various ways of deciding on that. Parties typically grant one another a free non-exclusive license to use each other's background IP for the purpose of the collaboration. So again, it's for the purpose of the collaboration and for the term of the agreement. So that's why it's really important to set out the purpose of the collaboration in the agreement. And it's just a good idea to keep an IP register. So to expressly record that background IP at the start. Say who has brought what to the party and differentiate between background and foreground IP. Okay, another important clause in research contracts are the rights that are granted. So this is not necessarily relevant only in research contracts, but in any IP-related contracts. So licenses, as we know, are agreements where the owner of the IP rights, which is called the licensor, permits a third party, which is the licensee, to make, use, sell, or import something which is relevant in the case of patents and designs, or copy, display, distribute, modify, for copyright. But that person retains ownership of the underlying intellectual property right. You can grant licenses under certain terms, so you can define territories, term of the license, and the payment options for royalties. And then many of you may already be aware of these, but there's a couple of different types of licenses. So an exclusive license is where there's only one licensee, which may use under selected parameters at the exclusion of others. And it gives a competitive edge to the licensee, and the licensor is excluded from using it commercially. So the licensor retains ownership, but they can't themselves commercialize. Non-exclusive means there can be more than one licensee under the selected parameters, and then a sole license is where one licensee gets access to the rights in conjunction with the licensor. And then you can provide, you can make provision for sub-licensing as well, where it's not exclusive. And that's where the licensee themselves could sub-license aspects of the IP to other parties, and the licensor provides, makes provision for that. Warranties are also important in any contract, especially IP contracts. It should be clearly defined. Watch out for blankets. IPs, that IP is unencumbered by third parties is kind of often difficult to prove or to show, or it might be impossible. You don't know what everyone is up to everywhere in the world. So just be careful of those, and do not warrant the results of the contract. So the sort of the output of the collaboration agreement. But important IP warranties do include that person X is the owner of the IP. The inventors are those who are named, that the IP meets certain requirements of novelty, inventiveness, utility. It's good to try to obtain warranties relating to validity, but it's also very difficult, especially if you're at the early stages of prosecution of a patent, for example. And so that's why those are often very contentious clauses, because, as I say, you could be at the early stage, or other patents or applications which could count against you themselves might be unpublished, or there might be secret use of IP that you're unaware of, completely unrelated. Sort of public research institutions, it's a good idea to avoid warranting patent validity as far as is possible. Obviously, you have to provide breach and termination clauses in your contracts. There should be notice, there should be reasonable time provided to remedy the breach, and setting out the grounds of termination And then, yeah, just be careful for clauses like it may be terminated at the sole discretion of person Y, or maybe terminated at any point. There needs to, you as a party to it want to make sure that you can't just be left in the dark without any warning, because the other party may just terminate it as and when they please. So yeah, be careful of those things. And then if there's termination without breach, it should be mutual and with reasonable notice. So you'll provide for that in the contract. So that's it for contracts. I'll take a few questions. I'm going to first just read while some of you might have a think. I'm going to see what's in the chat. Examples of reach through clauses, just to provide the logic. Okay, I see Rosemary has answered that one. What necessitates evergreen contracts within the patent space? So evergreening, for those of you who are unaware, it's mostly seen in the pharmaceutical industry, and that's where the term evergreen means it stays green and green and green. So patents we know as 20-year terms, but evergreening in the patent space means that you keep filing patents, and you kind of just keep extending protection for your invention. But remember, an invention must be new and inventive in order to be patentable, in order to be valid. So they keep making small modifications, which perhaps, and now dealing with in the pharmacy space, they improve the efficacy of the drug. And so that's evergreening. And then they'll introduce a slightly new product on the market, but now they've got a patent on that one, but that one has the most commercial value. And so in that space, they kind of just to keep extending their protection. I personally, my view is that I don't have a problem with it. I think if you are making improvements and there's a lot of funding and research and resources poured into that, you're entitled to your monopoly. You're entitled to that. So if you are meeting the substantive requirements of novelty and inventiveness, then I think you should be entitled to. Obviously, there's a whole different debate around accessibility to pharmaceuticals, but there are other provisions made for that, including compulsory licensing, and there's provisions in the TRIPS agreement around that as well. So just to answer the advocate's question, what necessitates evergreen contracts within the patent space? I assume what you mean is evergreen contracts are relating to evergreen patents. And well, what necessitates it? I mean, you want to retain your commercial advantage and economic benefit you can obtain from it. So that would be a driving factor for that. You can't have an evergreen patent where you have a patent that expires. The Patents Act in South Africa, and this probably is applicable in every country in the world, you can't have a license which precludes the exploitation of that invention beyond the term of the patent. So if my patent expires tomorrow, I can't have my license extend for the next 5 years and still stop you from using the invention which forms the subject matter of that patent. That is, those clauses in license agreements are automatically invalid in terms of the Patents Act in South Africa. And I would think that the position would be the same or very similar in most countries around the world. So you can't evergreen your contract where a patent expires, if I could kind of use those terms together. And I hope that answers that question. Okay, see there's 2 hands raised. Regina, yours was up first. Do you want to ask your question?
Yes, sir. My question is in relation to you know, mechanisms placed in contracts, especially pertaining to royalties in in um in relation to patents where we don't necessarily have like CMOs. Like with copyright, we do have CMOs that do like administer royalties on behalf of, you know, the rights holders. But for instances such as designers, for example, designers, and maybe I license my my design to somebody else to manufacture. How do we go about placing mechanisms to collect royalties if, let's say, the agreement was, you know, if that I license them my design, but then they have to grant me a certain percentage of royalties? Like, how do we go about that? Because we don't have CMOs in some instances, and I've also seen it in let's say in relation to traditional knowledge, or I don't know, is it traditional knowledge, or where let's say a certain pattern or type of cloth or would be associated to a group of people in a culture, and you take that print or design and you go put it on a fabric, for instance, to manufacture a fabric and etc. Like, how do you go about, and how do you go about compensating those people or placing mechanisms to collect royalties for those groups of people? Um, yeah, traditional knowledge. I think that's the word I was looking for.
Yeah. So, okay, before I deal with the traditional knowledge question, the provisions you make in the contract is that there are audited reports, every financial year, that sort of thing, so that you can see, well, how much profit is the licensee making, or what's their revenue, or whatever the case might be, and obviously the contract provides for royalties on the basis of that, or number of units sold, whatever the case might be. So you make provisions for that they must provide audited reports. Where they don't, they're in breach of contract, and where they don't pay the royalties due to you, as per those audited reports, they're in breach of contract. So that's sort of how you provide for that in contracts. Insofar as it relates to traditional knowledge, I'm not really sure that there's a clear answer to that. The principle's the same if there's a contract in place. But yeah, where someone uses the traditional design without authorization, without an agreement in place, then it needs to become a sort of a litigious matter, unfortunately, and then to determine the quantity of royalties due. I'm not really sure if that answers your question, but that's sort of what I can say on that topic.
All right, thank you, sir.
Okay, Advocate Nosibo.
Thank you very much. Back to evergreening. You'll agree with me that in the pharmaceutical space, evergreening happens. Let me give an example as a person who has been in the lab, because I'm a chemical analyst before everything else. You can develop an aspirin, right? And you change just one hydrocarbon in the stream, whether it's through titration, you end up with disprin, you to end up with paracetamol, and those then become different formulae that relate to the same entity, and it then registers those as patents because there has been a change in the formula or even the packaging. Now, this is what we know. That is what me and you know. If you go to the pharmacy, you look at generics and everything that's happening there. That's evergreening in an interesting way. The question then is, in the contract itself, where is evergreening happening outside contractual arrangements? That's the question I'm asking, because it's happening, and it's a monopoly type of behavior, because then you will have the owner of this patent tweaking it all the time and remaining a monopoly of that stream, which is the debate that we have now in Patent X and at WIPO. So the question for me is that where is that then contractually that a person can just evergreen for as long as he has a lab and access to titration?
I'm not
That's
sure I
the question I'm
understand
asking.
what the contractual, no one needs to give you permission to do that. So I'm not really sure what the contractual issue is. Could you expand on that?
I'm saying contractually, if for example you are a scientist, you an organic chemist person, you
Yes.
are having a laboratory, or you own a laboratory, or you lease it, and in terms, I'm saying in terms of the contract, right? In terms of the contract, as you are dealing with various service providers, right? You are country X or you are department X. You are dealing with various service providers in this space.
Mm-hmm.
At what point, let me say maybe, at what point do you prevent evergreening? Let me put it that way, because it is unconstitutional, but it's happening. So how do you prevent it if you were the Minister of Health?
Yeah, so I mean, I think we have different opinions on whether it's unconstitutional. Yeah, so I'm not sure, is your service provider the pharmaceutical company?
Yes, it can be the pharmaceutical company, but the issue is, by doing evergreening, you actually, if you look at least developed countries, you're closing off. If you look at a number of pandemics and what has happened to the pharmaceuticals, you're closing off because you are allowing this particular service provider to continually develop a brand and appendages of those brands.
Yeah, so to use your illustration of, modifying paracetamol, if the patent won't be covering paracetamol, it'll be covering some new formulation of it. So you're no longer precluded from, as soon as the patent for paracetamol expires, you're not precluded from using it. So it's only evergreening. It's only relevant to you if you want to use the new drug. But if you want to keep using the previous drug, you can. The evergreenings, the new patent's not going to stop that. So maybe
let's leave it. There's case law around the issue, but we can talk on the sidelines. There's a case law.
Okay.
There are case notes around the issue of evergreening, because you're actually recreating on the basis of the existing one, just so that you continue being the person in the space, in a monopoly sort of in that particular space.
Yes. Yeah. Yeah. I mean, it is a contentious issue, and as a IP attorney, my view is that protection of IP drives innovation. And the reason why I say that is because any corporation, if they can't be profitable, if they can't make, and obviously I'm looking at a world which is sorry, I've just forgotten the term, capitalist. I'm obviously looking at a capitalist world here. If you can't make a profit off of your product, you're gonna stop. You're gonna stop doing research. There's not gonna be new drugs for cancer. There's not gonna be new drugs for anything, because what's the incentive? And you're gonna stop developing. You're gonna stop innovating. If you can't protect what you do, you're gonna stop, and the world's gonna be worse off for it. That's my personal opinion. So yeah, I think we can take it on, move it on from there. But the value in IP and the value in protecting IP is around that, and I think IP is really important because it drives innovation, and I think it brings improvements to human lives. But yeah, any more questions? Yeah, so generics become available after the expiry of the patent. Otherwise, they've been infringing. But there are provisions made, as I mentioned earlier, in both South African Patents Act and in the TRIPS agreement, which is, I think I also mentioned yesterday, there's going to be changes. There's going to be a new Patents Act in the coming years. And there's actually going to be changes around specifically regulating patents for pharmaceuticals. But there are provisions for compulsory licenses if there's an abuse of the right. And I'm not saying the fact that IP rights exist or are good automatically means that there can't be abuse of it. I definitely think there could be abuse of it, and there are provisions made for that, for applying for compulsory licenses where, yeah. But I think maybe this is a bit off topic of IP management. So I'm going to move on to the challenges around commercializing technologies. So the first hurdle, I think, is how well do you really know your market? I think a lot of inventors think that they know their market, but I want to pose the question: well, how well do you really know your market? It might be bigger than you expect. So you need to identify the relevant technology field, what the competing inventions in that market are. Do you know all of the competing inventions, or perhaps you only know of those who have the most exposure, but there are others which are relevant. You need to look beyond the current products on the market, because remember, there's a lag between a patent and a product. You might develop your invention now, but you're not ready for market yet, but you fully can describe your invention. You apply for your patent, and it still takes a number of years before you get to market. In the meantime, you've got a granted patent. So if you're only looking at what's in the market now, you're missing what could be coming in the next few days, but it was published 3 years ago, and that could have informed your decision making. So it's important to know. So do you really know your market? What are the technologies saturated, and where are their gaps? What is the market's jurisdictional footprint? So where are patents filed? And that's often an indication of a major market. Where there are more patents filed, it's because there's more commercial value in that market. Is there freedom to operate? Will there be an infringement? Who are your competitors, directly or indirectly operating in that space? And identifying competitors could also mean identifying collaborators. So it's not just about who you're necessarily going to be competing against, but actually who you could join ventures with, for both benefits. And what are the filing trends? Is the market actually expanding or is it contracting? And again, we're looking beyond what you perhaps see in a newspaper, but we're looking at, well, there's actually a decline of filings in this area, or there's an increase in filings, which contradict what's currently happening, but will inform what might be happening in the very near future. So how do you overcome that hurdle? Well, one option is to get to know your market from IP perspective, and you can use IP analytics for strategic considerations. So I touched yesterday that one of the questions was, well, if there are free patent search databases out there, why would we use the commercial ones? It's because the free ones can't do this. You can't put in a search topic and generate a word cloud like this, or a patent landscape like this, where you're identifying peaks and troughs, peaks being areas of saturation or dense population of patents. And these databases, these tools we use, we're generating information, very important decision informing information like this, to know exactly what the patent or the technology landscape is. What are the competing inventions? Is there saturation? Are there gaps in the market? Can you identify those? I mentioned the market's jurisdictional footprint. So you can start seeing where are the major markets, where might there be freedom to operate. So maybe there's actually an opportunity in a certain country which has been overlooked by other competitors, and they haven't filed there. But there's absolutely, maybe you're a smaller startup company, you don't need the same sort of revenue streams in order to be profitable or make it worth it economically. So you might want to enter that market, and there hasn't in fact been patent protection there. So you can start getting to know, well, what do the jurisdictional footprints look like? As I mentioned, you can identify your competitors. So who are the top filers? Who do you want to monitor? Who do you want to collaborate with? Who's interacting with who? You can understand the relationships between players in the market. So you can see, oh, hang on, like Sony and LG are collaborating on this. Volkswagen and Ford are collaborating on producing this new chassis. And you can identify that through IP analytics. You can see there's co-applicants or there's license arrangements happening between these parties. And those things are happening before they come to market. So you're already having an idea of the interplay between various competitors in the market. And then the filing trends. So are you expecting an expanding or a contracting technology area? The second hurdle are your collaboration needs, or I pose the question, do you need a collaboration? So why would an entity decide to collaborate with an unrelated third party? And these are some of the factors. So there's perhaps complexity of operations or a resource constraint. Technology advancements, maybe the other party has expertise in a certain aspect of technology which you require. Or there are sustainability imperatives. Maybe it's more sustainable to collaborate, or safety and health concerns, regulatory compliance, global supply chain dynamics. So market competitiveness and expansion. You might have the technology know-how, but you don't have the market, or you don't have the supply chain logistical resources. And essentially what you're trying to do is you're trying to streamline innovative efforts. You want to stay or become relevant. You want to be competitive in a rapidly changing market and in an evolving global environment. And these are some of the factors why you would want to collaborate with third parties. So there's a couple of ways to think about collaboration, what the role collaboration plays. So what is the driving force behind the collaborative innovation? So you either want to innovate to collaborate, or you want to collaborate to innovate. So innovating to collaborate, that's where you have already created IP and you want to leverage that to facilitate the collaboration. It's innovation geared towards attracting interest from potential collaborators. When would you do this? Well, you have a specific skill or capability, you've identified a potential collaborator or a potential market or an opportunity, and you require another party to fully realize that potential. Yes, so you want to expand your reach, access to markets, or distribution networks, obtain commercial value through licensing or assignment. Remember, that's a form of collaboration, licensing. There are considerations. So you want to look at your technology and IP landscape that I've just touched on, your filing strategies, so territoriality. Is there a potential collaborator in that territory? You know, if you want to move into a market where there isn't someone who's established there, you know, obviously that there is perhaps no potential collaborator, but you know, it might be the other way around as well. And then the timing of your collaboration is also important. So is there really a proof of concept of the innovation? Is there a minimal viable product? You know, what is the stage of prosecution? If we're looking at patents, you know, has it already granted? Is it still pending? What are the examination reports looking like? Does it look valid? Is the scope going to be broad enough to cover the commercial embodiment, or too narrow that it can be designed around? So those are all relevant considerations. And then some of the downstream action points. So looking at IP and evaluation, that's obviously important for attracting people like investors. Of course, extremely difficult for an unproven commercialization. And we had this question yesterday, you know, how do you value your IP? And I've already, I suppose, answered that yesterday. You need to do your due diligences. So we discussed that yesterday as well. Looking at validity, freedom to operate, and commercial viability. The last one being perhaps less of an IP due diligence. You know, commercial viability is very different to validity or freedom to operate. And then, yeah, downstream, looking at licensing, assignments, joint ventures, sub-licensing, or other collaboration vehicles like services agreements or consultation arrangements. Those also, it could be very relevant. And those in themselves could also involve, you know, licensing and that sort of thing. The other way is to collaborate to innovate. So that's where you've identified a need for an innovation, but you lack the resources perhaps, or the know-how. I think very often a big issue is you lack funding. And so you're joining forces to streamline that development. And a common example is vehicle manufacturers. I mentioned now the example of Volkswagen and Ford. They've produced, you know, the Amarok bakkie and the Ranger bakkie are based on the same underlying body. Things like the Suzuki and Toyota have also been doing a lot of that collaboration. And so what that does is they sharing resources, their innovation costs come down. There's perhaps quicker development, that sort of thing, and you then perhaps become more profitable as a result of that. So before you want to commence this sort of a collaboration, you want to establish alignment in terms of your desired outcomes. So I mentioned that earlier when dealing with research contracts. What are your goals? You want to agree on who does what and who contributes and who creates what, who owns what. Again, just I mentioned this before, but it's so important. Who owns what? Who uses what and discloses what? So confidentiality. So I touched on that already. And defining your IP the background IP, and then the rights following termination. So the surviving clauses. And although these things can all be done orally, the most litigious and contentious issues I've seen in my position has stemmed from oral agreements. Reduce it to writing. Of course, there can still be room for interpretation and that sort of thing, but at least you have a basis for your argument, for basing it on. To enforce oral agreements, although they are valid, is extremely difficult, if maybe not even impossible. And then, your rollout plan. So the markets, the current markets, the future markets, potential other collaborators down the line. Are there any that you want to approach together? You can create an IP program. And then during that collaboration, looking at the overarching project management. So I mentioned, establishing a lead office between the collaborators. And then, of course, it's important to participate in knowledge sharing and transfer, because without that, if you're withholding that, you're really withholding the development. So when not to collaborate? Well, do you need to collaborate? Do you need to? Do you have one of those needs that I've listed there and mentioned earlier? Do you have one of those problems? If you do you need a collaborator to overcome them, or could you yourself overcome those needs somehow? So don't think just because I have a problem and there's someone else who could do it, that doesn't necessarily mean that you have to collaborate with them. Just, I think, stop, pause, ask the questions. Why would you not collaborate from IP perspective? Well, you've done your due diligence and you see, okay, well, IP is invalid, so there's no protection. Why would I collaborate with you, or perhaps take a license from you for IP which is not going to protect the commercial embodiment, or the IP is too narrow to cover the commercial embodiment? So again, no protection, or there's no freedom to operate. So I can't commercialize in any event because I'm going to be sued and suffer damages, or have to pay someone, suffer damages. Remember, I mentioned this yesterday, a valid patent does not mean that you are free to operate. A valid patent just means that there's a new inventive aspect over what's come before, but what's come before could still be broad enough to catch your commercial embodiment. And then looking at territoriality again with your due diligences. Is the market relevant? Okay, and then the third hurdle, in my view, which comes to successfully commercializing and innovative efforts, is exchange control. So in South Africa, we have the Currency and Exchanges Act, and this governs cross-border transactions. And what are those? Well, that's the export of capital from the Republic. And capital is defined as, well, capital or any right to capital. So that's the exportation is of capital or any right to capital, which is directly or indirectly exported. And the regulations were amended a number of years ago to include intellectual property as under the definition of capital. So there's an express provision in the Regs 10(1)(c), which provides for capital requiring exchange control approval for cross-border transactions. And that's any IP, so whether it's registered or unregistered. So we're looking at trademarks, patents, copyright, designs, trade secrets, plant breeders' rights, know-how, domain names, you name it. So any IP. And then exportation directly or indirectly, so both assignments and licenses. So the licensing one you might think, but that doesn't make sense. I still own the IP. But what you're doing is you're providing a foreigner the right to exploit your invention, where you yourself could have exercised it. And so you're indirectly exporting that IP. You retain the ownership and it'll come back to you. But licensing requires ex-con approval. So if I own a patent in the US, I don't have a presence in the US, but I want to have someone manufacture and commercialize in the US. So I grant them a license. I've identified the collaborator there. I've granted them a license. I need to obtain exchange control approval for that. So And then what you need to show is, well, is it at arm's length? Am I obtaining fair value? So for that IP, so that those were the royalties flowing back into the country. And the point of exchange control really is just, as I mentioned yesterday, it's to prevent the efflux of capital out of South Africa, and a lot of developing countries have these sort of provisions, because you want to protect the capital that you do have, and you want to be growing as a country. So to have funds flowing into the country is very beneficial. An example of where you're never going to get exchange control approval is where you sell a patent. Let's say it's a South African patent, you sell it to a foreign entity who then licenses it back to you to commercialize. So now what's happening is they pay you, so they're buying it from you, they pay you for the patent, and now you commercializing, but you have to pay them royalties. So now there's money flowing out of the country, and that's going to happen for the next 10, 20 years. You are not ever going to get approval for that sort of scenario. But yeah, so there are these sort of provisions, gatekeeping in place. So the obstacle, of course, is obtaining Treasury's approval. Being this, South African Reserve Bank deals with that, and for certain transactions, so where it is arm's length, that's unrelated entities, that sort of thing, the guidelines provided say that there are authorized dealers, which are certain banks in South Africa, and they can deal with the application and approve it. It doesn't need to go to the Reserve Bank. To go to the Reserve Bank is probably going to take quite a while. Some banks I've heard are a lot quicker than others as well. I won't name any, but I know that certain banks take a bit longer, some don't. But yeah, so ultimately you have to. And the reason why, well, apart from the fact that you should, it's lawful to do so. It's actually a criminal offence not to obtain exchange control approval for the export of capital. So if you're selling any IP or signing any IP in or out the country, and you're not obtaining exchange control approval, it is a criminal offence. Of course, you could face fines up to 40% of the transaction value, or a blocking order against your bank account. So these are very real sanctions. Can the hurdle be overcome? Well, it is an obstacle, but it's not one which can be overcome. So African residents may license intellectual property to non-resident parties at an arm's length and a fair market-related price for the term of the agreement. And this is an extract from the guidelines. So provided you meet these requirements, it might take a little bit of time to get the approval, but you will get it. So it is a hurdle, but it's not one that can't be overcome. It's really more just a delay. I'm quickly going to run through these, and then I'm going to take you through an exercise. So it's just an example of a difficult situation. So there's 4 parties based in various countries around the world. The one party 4 you'll see has a subsidiary in Germany as well. There's a collaboration between the parties and IPs to be assigned to party 1 based in the UK and Australia. There's agreements in place, so that's great. That provides for the assignments, which is good. Make those provisions in the contracts, and have it in writing. Practicalities are where maybe it gets a little bit more ugly. So South Africa requires, party 2 to party 1, that requires Reserve Bank approval. Party 3 to party 1 requires a foreign filing license, because party 3 is in the US, and their laws require foreign filing licenses. 4.124 requires German tax clearance, and then party 4 to party 1 requires Reserve Bank approval. So collaborations could work, but they could also be messy. So just be aware of the fact that, especially when dealing with countries or entities in different countries, there could be a lot of complex laws to get around, but it can be done, absolutely. And And all of this was required before filing the priority application, so before publication of the invention. So that kind of delayed the filing of the invention, and that then obviously has the risks that you're losing your priority dates is becoming is moving up a bit. Yeah, just some food for thought. Understand why you want to collaborate and what you want to achieve. Align your strategies, including IP management. Understand the different roles in the collaboration. Formalize the collaboration in writing and deal with ownership explicitly. Okay. So here's a scenario for a practical exercise. I'm just going to put up a poll that you can all vote on. It's a simple yes or no. And then we'll discuss it. So we have a collaboration between two parties. You are the owner of background IP, which relates to a trade secret process for producing a chemical. So it's not a registered patent. The chemical is publicly available. In other words, you're selling it on the market, and you have for over 10 years. So the question, can your collaboration partner file for valid patent protection in their own name? So we're disregarding contractual clauses or recourse here. Just look at, well, the scenario, can they file for valid patent protection? So I'll give you a minute or two to answer, and then we will see what that looks like. Okay. I see a few people writing no in the chat. Maybe they can't access the poll. So this is the results of the poll. I'm not sure if you're able to see this. So out of the 48 that voted, 25% yes, said that they can file for valid patent protection in their own name. And 36, so 75% said that no, they cannot. So before I say what the right answer is and the factors to consider, I would like to get some of you to maybe give some input as to why you said yes or no and what you think the relevant factors are for answering this the questions of the scenario. Regina, see your hand is up.
Yes, sir. I said no, and the reasons behind that is because even though the IP hadn't been patented, it is a trade, but rather is operated like a trade secret. That kind of relationship is usually governed by contracts, and it places certain obligations upon each party in contract, and there might be some, for instance, I could say anti-competition or restraint of trade clauses in there, and that's why I picked no. So you cannot disregard we cannot disregard the probable clauses put in place in the contract and for them to go file for that patent.
I fully agree with you that those contractual clauses will provide recourse for you, but that doesn't stop them doing it. So they've done it. They filed the patent. So my question more is, well, have they obtained a valid patent? Because remember that stuff was used as trade secrets. It wasn't in the public domain. So it doesn't form part of the prior art. So could they obtain a valid patent? Advocate Nosipo.
It's quite a dicey one, but let's start with you are very correct. It does not form part of prayer.
Sorry, your microphone is incredibly soft.
Can you hear me now?
Yes, that's perfect.
Yes, I'm sorry about that. It does not form part of prior art. So in terms of the elements of innovativeness, but the issue is this is a trade secret subject to specific security clearances, right? And the fact that you then use it, you are breaking the security rules pertaining to this particular product, because the fact that it's a trade secret, it means that in terms of the minimum security standards, they are sacrosanct. That's one. So when you subject it then into the process of registration as a patent, you've actually breached some important legal requirements that go with it. And so, even though there is no prior art that goes with it, but still, the validity of it can actually be attacked.
Okay. So yeah, you again very, very correct. That there's contractual recourse and also anti-competitive, or rather unlawful competition recourse. And you are correct that the validity of the patent can be attacked. Yeah, that's absolutely all correct. Anton?
I think the answer is quite easy. It's definitely no, because you can't obtain a valid patent because the product has already been in the public domain and there's no novelty to it.
Okay, yeah. So that's a very interesting and exceptional answer. The product that's in the market is the chemical.
Mm-hmm.
The invention is the process of producing the chemical. So the invention, it's slightly nuanced. I have asked you a very difficult question, which is in fact based on a true scenario, and I will run you through it now. It's quite complex in law, but I thought it would just be something interesting for you all to consider, and especially if you are commercializing and dealing with collaborators and trade secrets and patents. At the end of the day, you're going to be coming to an IP attorney to answer these questions. But for you to know the background, I mean, it's so advantageous for you as innovators and as tech transfer officers, and wherever you might come from. It's yeah. So I saw Isaac, you had your hand up. I'm keen to hear what you had to say.
What I wanted to add was that also this is not patentable because Section 25 of the Patents Act, it restricts an invention which has been commercialized in the Republic. So that is a no for patentability.
Mm.
Yeah.
So yeah, you on the track there of one of the relevant factors, and that's where has the process secretly been carried out, because that dictates whether it forms part of the prior art or not. Okay, so let me run you through this. First of all, South Africa is a non-examining country. I dealt with this yesterday. So any patent application filed in South Africa, including this trade secret information, it will proceed to grant, assuming all formalities have been met, were dealt with accordingly. So it will proceed to grant, and you'll get a granted patent. But any question regarding validity of a granted patent with claims incorporating that trade secret would only be determined or challenged before our courts. and that happens after grant. So when you're dealing with validity, it's not going to be upfront. Okay, that doesn't mean because you have to go to court that it's not an option. It's very much is, and the parties, in fact, the vast majority of litigation that we see at the firm gets settled before it lands up in courts. So I think very often people think, oh, well, court is going to take 5 years to enforce my patent. The process can very often end long before that and be much less expensive than parties think. So there's mainly two issues relevant in this scenario. So that's firstly, whether the invention, being a process, may be considered novel in terms of our law, and then the second issue is whether a patent granted on the invention is valid or is liable to attack. So whether it's liable to revocation. So in terms of the patent aspect now, those are the two factors that are relevant. Okay. The third one, I did put in brackets disregarding contractual recourse, but of course, in real life, you're not going to. So, but the reason why I do that is because in this scenario, this client that came to us with this problem, they were in a collaboration with a partner. They had our clients had the background IP, which was this process, and they then had this joint venture to move forward and produce or sort of make improvements, modifications, a new thing. And there's a lot of advantages for our client to this collaboration. I don't know what they all are, but they set out in black and white for us that they don't want to end the collaboration. Okay. Remember, often these collaborations, even if other party, unhappy with their behavior, these collaborations are sometimes so valuable to you as an entity that you may want to reconsider your approach. So they said to us, we don't want to enforce the contract against them. We want to know, are they going to obtain a valid patent in South Africa? Because then it's going to be relevant for us. And, are we going to be able to still, separate from them, have commercial prospect? And yeah, as I said, very clearly didn't want to end the relationship with this other party. So that's why I say contractual recourse is not always the obvious solution or option. It depends entirely on the circumstances. So I said, there's two issues here. Firstly, is the invention novel? And secondly, if there's a granted patent, would it be valid? So our law provides that an invention shall be deemed to be new if it has not been made publicly available immediately before the priority dates of that invention. So I dealt with that yesterday. The Patents Act also provides that an invention used secretly and on a commercial scale within South Africa shall also be deemed to form part of the prior art or the states of the art in terms of novelty. So, secret commercial use, that is exactly what is happening here. So your process is happening secretly, but it is commercial. You're producing products that you're selling on the market. South African courts haven't interpreted the meaning of the term states of the art insofar as it applies to novelty. Sorry, they have interpreted the meaning of the states of the art. The prior art must be an enabling disclosure. So I touched on enablement yesterday. It must enable the skilled reader to make the relevant apparatus substance or carry out the relevant process or method. Our courts have said that the prior art must plant the flag at the precise destination of the claims of the patents in issue. It must do more than offer a signpost on the road to the invention. So kind of what that implies is that if the trade secret process has been exercised commercially and secretly in South Africa, then the invention will not be considered novel in South Africa, just that's black and white because our law says that. So the invention will not meet the requirements of patentability irrespective of who files the patent application. However, that provision says only for secret commercial use in South Africa. If the secret commercial use, the secret commercial process was exercised in a country other than South Africa, the question then turns to whether the commercial sale or the public disclosure of the product, so the chemical, by a process, produced by the process. So whether that sale is in South Africa or elsewhere, it doesn't matter where it's sold, but it's publicly available. The question is whether the disclosure of the product also discloses the process, which destroys the novelty of the invention. So our courts haven't had a chance to look at this scenario or decide on it. On the one hand, it is arguable that public disclosure of the product is not an enabling disclosure, i.e. it does not plant a flag at the process. And that is what our law says in terms of enablement. So if the process doesn't disclose, and we dealt with this just now under the question of trade secrets as well. However, if that were the case, such that the process is novel, in other words, that the chemical product does not enable the process, you would arrive at a apparent paradox when you're assessing infringement. The reason for that is because the Patents Act also provides that a claim in respect of a patent for a process for producing any product shall be construed as extending to such product when produced by the claim process. So the provision relates to infringement only, not to novelty, but potentially leads to an unreasonable and absurd scenario when the background IP owner could be stopped from exploiting the products in South Africa, which are produced by the patent process. In other words, their own background IP trade secret process used to produce a product, they could be stopped from selling that product in South Africa because they're not the owner of the patent. So that would be a bit of a paradox, but that's what the law sort of leads to. But to complicate it matters more, there are differing views on whether the saying that which infringes if later anticipates if earlier is correct in South African law. So on the one hand, it has received authoritative approval by the courts as a test for anticipation, but on the other hand, has received criticism for conflating the rules governing quantitative determination of novelty and the rules governing determination of infringement. So I said our courts haven't looked at that scenario specifically. So if we look at European law, which our courts often regard as persuasive, methods are novel and therefore patentable if they cannot be determined or reverse engineered by analysis of the publicly disclosed product produced by the method. The corollary is true that a process which can be reverse engineered from the publicly disclosed product is not novel. So there's a possibility that the South African courts may come to a different conclusion, but it's likely that the European approach will be followed if such a matter were to come before our courts. And this is also in view of what is said about the law enablement. So the fact that the background IP owner has managed to keep the process a trade secret for 10 years is a strong indication that the process cannot be reverse engineered from the commercial product. So all that being said, it could very well be a novel process, novel in terms of patentability. So you get a novel process, you file a patent, it gets granted. Now the question turns to whether a patent granted for the method by the collaborator is valid or whether it's liable to be revoked. So our Patents Act again provides that it's a ground for revocation, that the grant of a patent is in fraud of the rights of the applicant or any person under or through whom he claims. It's a further ground for revocation that the patentee was not a person entitled to apply for the patent, and an entitled person may be the inventor or any person acquiring from him the right to apply. So remember, in this case now, the collaborator didn't get the right from the inventor, and the collaborator's in fraud of your rights as the background IP owner. The third relevant ground actually is not so relevant well, it's relevant, but it's not super important to discuss here. But there's a certain declaration, a form that you have to file, and that refers to the fact that you declare that you're the rightful owner, and if that form is false, contains a material false declaration, that's also another ground for revocation. So that it would automatically kind of kick in if there was fraud. So now, if the collaboration partner did not independently arrive at the trade secret, remember I said if it obtains it independently, it's not unlawfully obtained. So if they arrive at it independently, if they did not arrive at it independently, but gained it from the background IP owner, then the grounds of revocation I mentioned now will be relevant and the patent will be liable for revocation. Yeah. But if the if it were the other way around, in other words, they arrived at it independently, which is unlikely given the collaboration. But in the event that they did arrive at the process independently from you, notwithstanding that it was a trade secret, it can happen. Then the patent wouldn't be liable for revocation. What's important to note is that I mentioned in the scenario, our client, who was the background IP owner, didn't want to assert the contract against the partner, but it doesn't have to be the background IP owner who has to bring an application for revocation. It can be brought by any person. So even if our client decides not to attack the validity of the patent, any other person could attack it on those grounds of fraud if somehow they became aware of the fraud. So it's a very, very, very complex answer to the question. I hope it was at least interesting for you. But just know that there's a massive interplay between contracts, between collaboration, between trade secrets, between patents, between validity and novelty. So don't view intellectual property in isolation. You'll make a mistake if you do so. It's really important to look beyond that and look at all the factors that could apply. Okay, that's it from my side for today. But I am happy to take any more questions that there might be before we take a bit of a lunch break. Michael.
Thank you very much, Patrick, for the very insightful discussion. I've posted my question. Is it possible to protect the process without naming the trade secret or the secret product?
So the process is the secret. I'm not sure I follow.
No. Isn't it the product? In this case that we're discussing, isn't it the product that is secret?
No, the product is the commercial product is what's sold on the market. The secret is the process for producing it. Isaac?
Okay.
Yes. Thanks,
Thank
Patrick,
you.
for the wonderful presentation. So my question is based around the pharmaceutical products. So what I want to ask is, like here in South Africa, the Patents Act doesn't provide a grace period for pharmaceutical products for the developmental stage, the R&D period. Whereas in US jurisdiction, they do provide the grace period for the research and development of the product for that entire period until the product gets into the market. So as far as the South African patent regime is concerned, or IP regime is concerned, what is our position with regard to grace period for pharmaceutical products for like for an extension of the period for which those
Yes.
companies, So basically that's
it's not a grace period insofar as it relates to novelty, but you mean that if it takes 5 years to prosecute the patent before you get grants in the US, they might add 5 years onto the term at the end. So that is provided for in US law. I don't think it is actually applied very often. In fact, I'm not too aware of that. So I'm not too sure what your question is. South Africa's position, we obviously don't have those same provisions. And look, it's kind of part and parcel of applying for patent protection, is that it does go through the examination phase in prosecution. So it's expected. There's the 20-year term. What that provision really provides for is if there's like a specific unwarranted delay by the examiner. But if it's in such a case, they might extend it. But if it's the usual 2 or 3 years of prosecution, the usual timelines, they don't extend it. So it's just a provision that's made for where there's like a delay, almost an unfair delay, which affects the patentee and is not caused by the patentee but by the examiner. I don't think it's really, and it's peculiar to the US and I think a couple of other countries, but it's not largely applied throughout the world. I don't think it's because the thing is, it's as relevant for pharmaceuticals as it is for other innovation. Prosecution is no less complex, and there's always a benefit in any event for public to gain access to generics. So that's just my perspective. But I hope that answers your question.
All right, thanks, Patrick.
I see there's a question on the chat. Besides CIPC, what are the other regulatory bodies that govern patent filing? So in South Africa, it's only the Patent Office, which forms part of the CIPC. Every country has its own patents office. So that's the only regulatory body in South Africa. First file principle applied to patents, like in the case of trademark filing. It's also not a straightforward answer. If they are co-pending applications, so one has been filed just after the other, but they're both pending and haven't been granted or been published, then the earlier one. But then if it's in South Africa, it does count against the inventiveness, against the novelty of the later one, even though it hasn't been published. Remember, prior art is usually defined as that which has been publicly available. So if the earlier application is still pending, that means it hasn't been published. It kind of contradicts that, but the exception is made. And so what that means is that if the earlier one counts against the later one won't be valid, so you won't get a granted patent, or you will get a granted patent in South Africa, but it won't be valid. So the effect of that is that the first to file then does get the monopoly. I didn't answer that very eloquently, but I hope that does answer your question. Okay, we are a bit over time for our lunch break, but maybe if there's more questions later in the afternoon, based on this. We can take those again if there's some time. But I do want to give us all a break, and then give Nikki her due time to present this afternoon, because she's going to absolutely blow us out the water. I'm looking forward to it. Not to set it up for any disappointment, but no, yeah. So I think I'm not sure, Rosemary, Nikki, should we still meet at past, or should we give it a little bit longer, given that we had about 13 minutes past now?
Right, I think we can stretch it a little longer, but for those who might have a hard stop at 2, we don't want to stretch it too long. So let's take 20 minutes and meet back at 12:35.
Fantastic.
Okay, that's okay with me. Thank you.
Good.
Thanks very much.
Thanks, everyone. Sorry about the short break, but it's been great to see the engagement and get the different insights, bearing in mind that many of you come from different backgrounds. See you back at 12:35.
Good afternoon, everyone. I hope that everyone is back at lunch. I'll continue with today's session, but my role will be looking at technology transfer processes, the realities of technology transfer processes, like translating research into real-life impact, be it social impact or commercial viability. Yesterday, we dealt with IP management, basics of IP management, and I covered mostly IP management on higher education institutions or institutions that are publicly funded, which I believe that this policy or South African Act applies to public entities like your science councils, your research councils. So Patrick earlier on dwell on mostly on contracts and commercialization, more like on the private entities. But South African Act, I believe that it applies to all the entities. So what I will be looking at, sorry about that. So what I'll be covering is the technology transfer processes, the realities, and in higher education institutions, and what does it mean in higher education context, and what is the role of institution, roles of engagement in terms of like engaging faculties and the relevant stakeholders, the key stakeholders in transferring the technology transfer. And of course, there are challenges, as you may know. If you are publicly funded, there are limitations. You might have limited resources in terms of capacity, constraints, that's lack of expertise in the technology transfer processes, as well as funding. As technology transfer officers, of course, we are custodians of the Act, and we've got limited resources. All we do is to assist the institutions or the researchers, especially from public research, innovative research, translate that research. But it needs resources, so we assist as technology transfer officers to protect those ideas emanating from research, mainly research. And of course, there's always gaps, which is challenges in terms of like pre-seed funding. And we rely mostly on government entities like TIA for the seed funding. And sometimes some of those technologies don't qualify for the seed funding because there's the gap, because we only protect taking that technology further. It depends on inventor or the technology transfer office. That's where the challenges are. So it also boils down to the type of research that institutions are doing. I think maybe institutions based on the national agenda or institutional policy, that the type of funding or industry that is attracted by institution is based on the type of research that is done, or it could be the other way, that the institution are involved in the type of research that doesn't attract industry, which is a problem now when it comes to funding, as we are entirely dependent on government funds. And that boils down to the engagement, of course, the programs, awareness programs within the institutions. What type of awareness program are we talking about? Do we engage faculties? Do we get to know what is happening in the faculties, other than us telling them what to do or how to protect intellectual property? And at times, some of the challenges we find that some researchers will feel that the policies are too restrictive in terms of like they need to publish. So there's this principle or perspective that you need to publish or perish, or at the same time, we're telling them that they need to protect. But now I think we need to balance as institutions that, okay, maybe come up with programs or incentives that will balance that. Okay, you could actually do both. You can protect first and then publish later, so that you don't lose the value of your IP, of your research. And then the other programs that most institutions, including my one, is to scout the IP when they have research days, when they have faculties have engagements, and a lot of activities coming from University of Technologies. There are a lot of activities that include industry. So we normally get engaged the industry. When they visit faculties, maybe faculty of engineering, we get to know what is happening, the type of engagement that they have, and to actually conscientize the researchers. Not to say that researchers don't know IP, but sometimes we feel that they don't, there's no buy-in from researchers in terms of IP. So what do you mean by technology transfer? Some of you know, because I know that I've got colleagues that are here.
Sorry to interrupt. You're not in slideshow mode. So
Okay.
that might be easier.
Okay, sorry.
Sorry to interrupt.
Sorry about that. Colleagues, feel free to stop me anytime. And today it's going to be different. Yesterday I had exercises at the end, but today, because this is overlapping with yesterday's one, I know part of the exercise yesterday was including the processes, the disclosure process, commercialization process, as well as technology transfer. So it might sound like a repetition, but this is more like a step-by-step process of how institutions work. So when we're looking at this engagement, we actually more like on the relationships that the institution build. And the funding normally depends on the type of industry that is involved in higher education institutions. So normally in the region where I'm in, will probably attend certain networks, and some of the industry will tell us that we're not visible. And you ask yourself that, okay, we've got big faculties that do particular field, maybe engineering or architect, but we are being told. I think it boils down to the type of research, the type of relationship that we build as institution is very important to attract the industry partners and collaboration and funding that is relevant, or that will take this that the research outcomes or outputs into real life problems. And then as well, it also depends on the experts in the field, on the type of relationship that they have with the industry. That sometimes I'll say we blame. I think I'm not trying to blame researchers. At the same time, it's also the policies and the type of funding. I'll give an example of TIA. That's where tech transfer is dependent on. TIA call will be circulated, and you find that it does not speak to the type of research that we're doing. What do we say now to researchers? Because sometimes they want to apply, or maybe the call will say you need to have an industry partner, or maybe the type of research that the institution is involved in doesn't speak to the industry or to that particular national agenda. For instance, you've got if the call is about, or the national agenda, research agenda is about green economy, and the policy of the institution or the strategy is something different. So sometimes there's disconnect, or maybe there's a conflict or misalignment between the policy, university policy, and the national agenda. Not to say that the university must now change their strategy. If the institutional strategy is 5 years, so I think those are the things. But at the same time, the type of research that you are doing, it will give you an opportunity to attract the funding. And even when it comes to commercialization or translate that research, if you are able to maintain, let's say, for instance, the research institutes, most of the research institutes, they generate their own funding. So it is very difficult sometimes to restrict them. Not to say we don't restrict, but we guide them, but it is very difficult to tell them what to do because they generate their own funding. But at the same time, we would guide them saying that, okay, if you do this, we are actually custodian of the Intellectual Property Rights Act. So anything that is emanating from this institution, before you take it outside, before you go and file it outside, before you collaborate, ensure that you comply with the national policy. And as I mentioned earlier on, that the challenges that we are facing as institutions, time constraints. And I think yesterday we touched base on something: why is IP often overlooked? It's overlooked because of the workloads towards academics. As we know that in higher education institutions or universities, the core business of the universities is to teach. Now you're going to tell a researcher that, no, go and innovate, go and do research. And then where are the incentives? So look at the fact that if somebody published, there's a subsidy, government subsidy that is guaranteed from DHET on condition that you actually publish on an accredited journal in South Africa. So now when it comes to IP, and then we still say, okay, we're going to rely on the on government, the very same government or the office, the regulatory office or NIPMO, who only gives us funding just to run the office. So I think it boils down to the university strategy as well as the type of research that is being done within the institution. So it's the alignment of the policy, the strategy, and then as well as the lack of funding in product development. As I mentioned earlier on, that the type of funding that we have at technology transfer offices is it's for IP prostitution. It means that we only cover, we pay the fees, the lawyers to protect. When it comes to taking it further, then it's up to the inventor. So what do we say now? What happens? Most of the challenges, you might find that there's a gap, or maybe by the time the technology is on the next stage or we have to file, then it has lapsed because there's no development or there's no progress. So some of the researchers, they will feel demoralized. So I think it's one of the challenges that the funding, or maybe we don't market enough what is really happening in the institution, but we try to align whatever is happening, and we try through those scouting project, departmental visits, to say that we're not trying to control you. Let's look at the collaborative agreement, and then let's take it further. And then, of course, the industry networks. I think industry networks are very important. I think maybe if the researchers will actually network with the industry, we're trying to do that. The program within our institution starting last year, going to the industry, telling them that these are the niche areas in our University of Technologies. Maybe in that way, industry will be more interested just to network and get to hear, so that if they have programs, similar programs, they are able to approach us, or maybe if they want to run research, instead of going to another province, here we are as the University of Technology. And then maybe there's a lack of understanding towards our stakeholders, internal stakeholders, when it comes to IP protection. Maybe they feel that we are trying to control them, more than trying to safeguard the intellectual property. I think maybe they engage, because we've got, I believe that each and every institution will have a technology transfer office, and we've got researchers interested hearts, because our office, the mandate is to safeguard that research. So without researchers, without innovative researchers, we might as well close shop. So I think it also the type of relationship And then the fact that our policies, I think any tech transfer office, if you've got a collaborative research, those policies are quite flexible. And of course, alignment is very important. And as I mentioned earlier on, a public parish paradigm, you can actually do both. You can protect first and publish later. If you are writing a thesis, there's a process of like holding it back, embargo, and then you protect, and then you can publish. Even if it doesn't stop you from graduating. If you are a master's student or PhD, you're gonna get your graduation, but the library or the institution wouldn't publish your thesis until it is protected provisionally. Then it is you are in a better place. And of course, government funding is under strain because that's the biggest funder of our office, technology transfer offices. And of course, commitments, the time commitment with scientists, because they are expected to research or teach, and then sometimes to do more work in terms of collaborations or doing innovative research or patents, developing technologies. It might affect their work of contract, which is core business of the university, which is teaching. And then maybe the framework is not aligned with the commercialization framework, is not aligned with the policy. And sometimes it's very difficult. You might find that there's a gap in terms of like taking it to the market. Maybe before we file for patent, maybe researchers need to do an expression of interest or go to an industry to check if they'll be interested in that particular technology. And the other thing that I would like to mention, that because of those constraints, we don't file everything. We check if it's relevant to the market. We would have done due diligence, working with our external stakeholders like with lawyers that will give feedback on the best protecting strategy. And then when it comes to IP awareness, I think I touched based on this one. We do those departmental visits, faculty boards, and as when they are doing open days in their faculties. And in my institution, there's an entrepreneurship and innovation day for each and every faculty. So we actually do the roadshows and to conscientize them. But raising awareness and them visiting our office, it's another issue. But at least they are aware of what they are doing, that if you are taking your research or you go and file it somewhere else or collaborate with someone, they've got consequences, or there are consequences to face. But again, we can't punish everybody. So I think the other thing that we're trying to do is to start this initiative, the awareness from the final years undergraduates, that by the time they know, I know CIPC does outreach program, but we do collaborate with them so that they can just anyone within the institution, whether it's entrepreneurship desk or those incubators, that at least they understand that there's IP, or if there's IP, what to do. Even if they leave the institution, we've got this policy or the strategy, our strategy that says that we are an engaged university, that at least even our alumni, if they develop something or they decide to leave the DUT, they should plow back. So there are a lot of strategies that we do trying to raise awareness, because there is a gap, a big gap there. And the other one is, of course, apart from the initiatives, it's the incentives. Incentives are very important. Sometimes it doesn't have to be monetary. Maybe the awards, we normally have institutional awards at the university. We recognize those innovators with IP. Yes, there will be recognition for publication, which normally happens through incentives and through the faculties. But during the institutional awards, the yearly awards, those ones get incentive, they get awards, and they get some incentive, monetary or non-monetary. And the incentives motivate action. So if you know that at least you'll be rewarded, and at least it motivates researchers to be innovative. And of course, the whole idea is to build entrepreneurial culture, because that IP, for it to make an impact, it needs to be commercialized. So I think the university as well has a role in terms of like fostering the culture of entrepreneurship and innovation within the institution, and to bridge the gap between the industry and the research. And I've mentioned the challenges that, okay, even with incentive, it's not one size fits all. It's not guaranteed, but it has to be realistic that we need to focus on the niche areas of the institution and see what works for us in order to attract the industry, irrespective of the research agenda. And then the financial incentives, of course, it will be like once the technology is commercialized, there will be royalties based on the institutional policy. If not, we actually look at the National Act, Intellectual Property Act, and maybe come up with a support fund, the pre-seed fund within the institution. In my institution, we do have an incubation program, a pre-seed fund that will actually develop the technology further or work on the proof of concept before they apply for TIA seed fund. And we also collaborate with other entities, external entities, private entities other than TIA for seed funding. And of course, non-financial awards, that is IP awards and publication. And it actually, especially with art and design, we do have a faculty of art and design, and they do have incentive by the HET that with the normal faculties, if you publish in an accredited journal, you have 1 unit, but with creative outputs, you have 2. So even that, and then if you take it further and protect it, it's another award. So we do have that such initiatives in our institution. And then we do have through our incubation program, they are in mentorship program. I know other institutions, bigger institutions, because I've worked in rural institutions and I'm working at the University of Technology. I know there are bigger institutions that might have resources that we don't have, but with us, the problem for us or for researchers to be reluctant in protecting or taking further their technologies because there's that gap of pre-seed funding, which we're working on. There are others incentives through WIPO. This is the website that is got nothing to do for other countries that are not South African countries that they can go through, and there are programs and incentives in WIPO if you have an IP that will guide you. And then through IP scouting, the whole idea is to strengthen the relationship between our office, researchers, and even the institutional management. And of course, we're trying to get a buy-in from the policymakers within the institution. And while we encourage invention, it's also very important that we actually have a good relationship or getting to know, instead of going to a department and ask them, this is what you need to do. It's them, what can we do for you, or what can you do for us? In that way, through our innovation in Indaba, we get to know what are their pains, what their problems, what their challenges. In a way, it will affect the policy formulation or the review of the innovation policy. As this innovation committee, the key takeaways, of course, the first point of contact is the technology transfer office. We might not have all the resources, but we will guide you. And then the efforts towards building a meaningful relationship, not only within the institution, but with the various stakeholders or external stakeholders. And collaboration doesn't mean you have to give us money. The type of research that you are doing, if you feel that our institution has a strong point in a particular field, we're not big in agriculture, we could collaborate with an institution within South Africa or externally. There are other funding instruments or capacity development building like this one, Erasmus Plus, that encourage that. So I think the type of innovation, I think it's high time now when we research, as researchers, we think of the market. That if that type of research you're doing, you think of the market, you are in a better position now to attract industry. And then there are various platforms, of course, not only through tech transfer, a platform like this that will give you a kind of like type of capacity development that the institution might not have. And I think for us as institution, let's not overpromise. Let's be honest. Authenticity is key. So with that, ladies and gentlemen, I'll say thank you.
Thank you.
I can't see the, what do you call it? I can't see the charts. I'll take questions, and I know some of the issues that are covered here are similar to yesterday because they overlap the process, the technology transfer process, and the IP process. And some of the things might have been covered by Patrick earlier on in terms of like collaborative agreements, but these also dependent on the institutional policies. It's not one size fits all. Okay, Mr. Msowoya, yeah.
No, thank you for the nice presentation. Actually, you have spoken very well. Actually, as if you are speaking to our newly established. I work with Mzuzu University in Malawi.
Okay, sir.
And the question that I have is that I know here in Malawi, this issue of IP, I think we are starting them just recently. And
Yes.
even our university, because we were given the mandate to act as a TTO, Technology Transfer Office. That was last year.
Yes.
Yeah, so I wanted to find out, I've seen the incentive that you have put up in terms of how you have done engagement with things, among others. I wanted to learn from you. I want to learn from you in terms of how do you make the academy to keep on that drive that I think this is the lot. Because we have been engaging the deans, we have been organizing meetings, but I don't see that kind of drive, like the pushing power from their end. How should we do it? How best can we do it? Thank you.
I think for me, if I get it correctly, when it comes to, I think it boils down, the first point of contact will be looking at the university strategy. Does it speak to the innovation? Because if it doesn't speak to the innovation, then there's a challenge of funding. That the technology transfer offices, the way they are designed to maintain the office, to raise awareness, and to assist in terms of prosecution. But now taking the technology further, it also depends on the type of technology. As I mentioned earlier on, that one of our biggest funders in South Africa is Technology Innovation Agency. It's our funder. And then if their call does not speak to that particular research theme, then it means that there's a gap. That means there's a problem now in terms of like developing that technology further. Would have filed the patent further. So as much as you can raise the awareness, go to faculties, go to departments, the institution maybe needs to set up a fund, a separate fund, like my institution, that we came up with this funding instrument that we call a pre-seed fund, because we realized we identified the gap. Well, now we're looking at the university strategy, and then like trying to bridge that gap. The institution had to come up with this innovation fund, seeing that there's no pre-seed fund. At the same time, you look at the national agenda. What does that mean? Where is it going? And what type of research that you're going? Because not only you're going to be depending on this type of funding, the type of calls or of the agenda, if we're saying that it's green economy, and then what type of research should you focus on? And you also attend these networks, industry networks, and you get to learn what industry needs. I hope I've answered your question.
Yes, you have. Thank you a lot for that. Thank you.
Yeah. Okay, I think on the charts, I think they want to know if this will be shared. Yes, they will be shared. I think Rosemary has responded to that. Roseanne, can you unmute yourself?
Good day, and thank you for a very nice presentation.
Yes.
I'm a master's student at the University of Limpopo, and I also hold LLB from UNISA, and I'm also a research assistant. My interest is in IP as well, and one day I would like to become a patent attorney. But we're having a challenge at our university. It's very difficult for our lecturers or the supervisors to come out and present their work at the TTO office how what can we do for us to be able to convince them to come so that they can come to the TTO office, and then we can help them with this whole process of filing the patents and stuff. Like, it's like they don't trust us with their work. I don't know, but it's hard for us to find them, to talk with them, to hunt them or to scout them. I don't know if it's the right word.
So you are a researcher, and then now you're saying that it's difficult to reach out to tech transfer office.
No, not to
Oh,
TTO.
the other way. Okay.
Yes, it's hard for supervisors, people that are
Yes.
conducting research, right?
Yes.
To go to the TTO office, you understand?
Yes.
And try to go through this process of patenting their work and stuff. They don't want to do it. How can the TTO office convince them?
With us, I think it's those departmental visits and not waiting for researchers to come to the office. Our TTO office, we got those departmental visits, and we've got pop-ups whereby any activity that is happening, if now it's orientation, we know that they are students, but we're trying to plant the seed or growing our own timber, that even if you know nothing about what TTO, we know that with TTO we mostly focus on research, but we feel that the undergrads are very creative, so we start there. That's another aspect of dealing with that. And then the other one is for TTO, if they go during those faculty boards or research committees and present what this means. And sometimes this IP thing is often misinterpreted, that, okay, the institution, especially when it comes to the act, saying that as long as you are publicly funded, you are using university funds, then you don't own IP. So I think if you go and present to the researchers while they are there in the research committee, higher degrees committee, that no, actually it doesn't take away the fact that you are the inventor. I think the problem with researchers or academic researchers is the issue of ownership, that it's not the institution that decides that. Even if you're taking it to the law firms to say, okay, let's say, for instance, there's a collaborative research, there's a IP that is being registered by two institutions, the type of feedback that you get from those law firms will be like, who's owning here? Because this institution are both publicly funded, so who's gonna own what? Because at the end of the, when it comes to commercialization at a later stage, there might be a problem when it comes who owns what once it's commercialized. So I think the IP awareness is not a once-off thing. It's like you are nurturing it. It's like when you're planting something, a seed, you have to nurture it until there's a buy-in. I'm telling you, this is a universal problem. The Act came into law in 2010, but we're still talking about IP awareness. It's not something that you're just going to do it once and get away with it. So you speak about the ownership. What does that mean? You speak about publication. That is, we understand that you need to publish, but you can publish before, you can protect before you publish, so that you are in a better position. If you don't want to open a company, there are different models of commercialization. If you don't want a spin-off, you can license it somewhere. We can assist you as a TTO office. If you don't have that, you consult. I think in this space, if you don't have anything, you get guidance from NICMO. I think that would be my contribution to the awareness campaigns. Thank you.
Thank you, ma'am.
Any other questions? And with colleagues that are from other institutions, feel free to give us insights, because we are coming from, you might have resources that we might have, and feel free to, because we want to draw our conclusion, of course, from the insights from this, that yes, we do have this step by step, and what are the challenges and how do you tackle those challenges? And in my view, I'm only speaking on behalf of higher educations in South Africa. It might be a different case in other countries.
Nikki, I see here's a question from earlier, which I think you would be suited to answer. It was
Yes.
from Advocate Nosipro. She says, in your experience, how is the interaction between NIPMO and the Reserve Bank, ensuring that research index strategic thrusts of the country are not negatively affected by the selling of IP?
I'm gonna say, unfortunately, we haven't had an offshore commercialization, because I think that's when that experience that's just, or the question is related to that. What if somebody is taking their IP offshore? So in our instance, it's normally the local ones, and if there's that part of like co-ownership with countries, I think, because we're based in KZN. So some of the collaborative research would be based in India, but we normally actually set it early stage that, okay, in terms of ownership, who owns what, and where is this research done, whose resources are done. But in terms of like commercialization offshore, we haven't reached that level. But I think NIPMO will guide, and I think there should be people here from I'm not sure if more people are still here.
I can
from UCT.
potentially come in there, having dealt with a couple of these. And the processes actually reference each other. So when you put in the SARB application, they will ask about NIPMO approval and vice versa. When you put in the NIPMO approval for assignment offshore, they will also ask you to show evidence of the SARB application. So I think the two do work together. At the same time, there's also the opposite argument. Sometimes we can keep things a little too close and land up losing opportunities by trying to do everything ourselves when it can be better done elsewhere. And so a broad view needs to be taken, and sometimes you need to look across the value chain and to see certain parts of the process might better happen offshore. But I think the experiences that I had in each case when we made the applications were approved by both NIPMO and SARB.
Okay, any other questions, colleagues?
And I
It's
think
Friday. I think it's
we'll be
Friday.
wrapping up now. So any questions on any aspects from the last 2 days, feel free to ask to either of the presenters. And again, also encouraging any of the participants who have anything to add to the discussion, put your hands up or add to the chat. This is your time for us to wrap up. If your question is focused at one of the presenters in particular, you can just indicate that. And also great for us to hear who you are, where you're from, to have that perspective. Thanks.
I think there are two hands, Advocate Nosipo and Michael. Yeah.
Thank you very much. I hope I'm audible.
Yes, you are audible.
Okay. I think Rosemary is saying it's time for disclosure, full disclosure. Yes. Well, I'm an IP practitioner. Actually practicing in the space and in cybersecurity and AI. At UNISA, lecturing the same. And that's who I am. I've been an advocate for some years. I belong to the Gauteng Society of Advocates. I've been in the military, as you might realize, and that's where the love for IP and why I then specialized in IP at University of Pretoria and in cyber law. So for me, what is important about these sessions are about always pulling the crowd of, they call them, there's a term that they are using in terms of the various sectors and skills. For me, these sessions are important because, one, they deal with real issues, which is one important thing that has happened. The second thing is that you always learn new things if you have an open mind. I can't begin to even talk about how much I've learned from this engagement from a different perspective than from the perspective that would have been run by the similar unit at UNISA, because we do the same at UNISA, but the perspective was quite different and quite helpful. But also the basic elementary focus on issues of IP and the simplicity at which the issues were dealt with was quite encouraging. I mean, when you look at the selling of IP and how it was presented, it's let alone then that there are other nuances that are there. Hence, I was asking NIPMO and everything. But then coming to the way forward, because this is not about us, it's about us and the people who must grow in this sector. Like I said, I have students that I'm lecturing. It would be nice for them to participate in these sessions, which takes me to the second question to say, what do you have a schedule of these programs so that then people can actually then make them visible to the students, and also a program like the WIPO programs, for example, that you are able then to know that at this time, this is what is happening, and you are able then to align to that. Obviously, the third one, and the most important one, for me at least, is that how do we then share our individual skills within this program? What is the process of participating now at another level in terms of then sharing the skills in webinars in the IP related areas like we do in cybersecurity and AI. So those are the issues, and of course we appreciate the partnership, and of course I think the information from Durban was quite helpful, because it was very practical, and I think this is where we fail sometimes as IP persons. I actually provide pro bono support to some of the young innovators who are part of there's a program within DST where they apply for tenders. And what I observed there is that you will be finding that there is a notification. And as part of this notification, they are told about everything and everything. No one tells them about the IP side of things. And the intersection of these things becomes important, because then you'll find their IP being used or abused somewhere without their notification. Hence, then I'm asking, what are the possibilities, or how do people participate in these sessions in a more meaningful way? Thank you very much.
Thanks, great to get your perspective.
I think, Rosemary, I think that one was for you in terms of like of this platform.
Right, so we have posted links, and when we share the slides, we'll also have additional links. So there's the opportunity for you to sign up, and there are different ways to get involved with the project. One of the things we're doing, there are various stakeholder engagement events, which are particularly aimed at people like yourself. So there's going to be an online event this year, I think, as well as one that will be held somewhere in Africa. It hasn't been fixed yet. So also, if you signed up to the platform, you'll receive notification of all of that, and really welcome the involvement. Also, through the evaluation forms, please provide any suggestions for the project, for Sarima as well, that we can take into account in our future events and activities. Thanks.
To add on that, Dr. Advocate, I think you actually highlighted a very important thing there, that learning does not stop. As you say that you yourself are in the field, and I've been to UNISA during their Innovation Week, and I was there to learn, and I've learned a lot. So I think it's not one size fits all. So it's very important us as technology transfer offices or practitioner to learn from one another and participate in other institutional events. And I also want to mention with the lady from Limpopo. I've been to Limpopo. I think they had a Moringa conference last year. So I think what they did, because they are big, it's also important for institution to focus on their niche, on what they have. Because normally with rural institutions, the focus will be more on the social impact. Maybe you've got indigenous plant or traditional plant that is only available in a region in a certain region in Limpopo. But now, how do you take that? How do you translate? How do you focus, or how do you do research on that, and taking that research into translate into a product, or coming up with a solution, innovative solution that will address the regional issues. So I think problems. So I think as institution, apart from looking at the type of research that you do, look at what you have. In KZN, we are big in sugar cane. Same applies to Mpumalanga. In KZN, we had sweet potato, we have amadumbe. Maybe if you can focus on that type of research or in type of innovation. So I think for me, other than looking at one-way strategy, single strategy, saying that, okay, tech transfer need to do this, do research that will be speak to market. Thank you. Michael, I think you're next, and then Divine. Those are the hands that are up.
Thank you very much, ma'am, for the nice presentation.
Thank you, sir.
I'm from Congo,
Yes.
Dr. Engineer. But I've been in the space of innovation for quite a while, being myself an inventor. Well, when I was still in South Africa, at one of the biggest institutions there, one of the, let me call it, struggles or challenges that we had is the balance between the, how do you call it again, the positive balance sheet, let me put it this way, of the institution versus the performance indicators of the number of IP that are generated, are created. Okay? Because I mean, as innovators and inventors, we're there pumping innovations out there. But the institution will look at them and say, if you look at the balance sheet, we don't have enough money either to file or to maintain. Then they just drop it. Now, you as a TTO manager, how do you go about getting that balance right and not losing
Yes.
the best innovation of your institution? Thank you.
Yes, thank you so much. So that was a comment, right? Thank you so much. Okay, Divine, you are next.
Yeah, thank you, Reno. I'm Banda Fabian
Okay,
from the
sorry,
University of
Divine.
Zambia. So I'm
Sorry,
using
Divine.
my account. Divine. Yes.
Sorry, Divine. I didn't get
Mine.
my answer. Sorry, Divine. Sorry to cut you. I mean, ma'am, it was a question
Yes.
to say, as a manager of TTO,
Yes, sir.
how do you get the balance right? How do you not reject the innovations or the inventions from your institution, while maintaining the positive balance sheet of your company, of your institution? Because I mean, I know it's a real fact that you can drop inventions, you can't file them, you can't maintain them. Why? Because you don't have money to prosecute, or you don't have money to maintain the inventions or the patent. Now, how do you do it? What is the strategy that you're putting in place in your institution? Thank you.
Okay, for us, okay, so I didn't get the last part. Sorry about that. For us, anything that is protected, at least we do have resources to maintain them as long as there's progress. the challenge is like if there's no progress after, let's say, for instance, provisional patent after 12 months, or you just abandon it, then we have no choice but to let it lapse because we want to see progress because as we know that protecting intellectual property is a very expensive exercise. And secondly, in order to balance that work was the type of incentive that is in place right now, we know that once it's protected, you need to take it further, which is developing it further, or you need more funding to develop it further. So to bridge that gap, we've got this incubation program. The incubation program doesn't only give you money, but it gives you the skills and expertise and the networks that will be relevant to your technology or your innovation. At least now you are in a better position to attract the funding. But there hasn't been a situation whereby we're saying that, okay, especially if we're already protected, to say, okay, we're going to just leave that one. It will also depend on your commitment. But in certain cases, yes, we might not file everything. We also look at the university strategy. What are the priorities of the strategy? We do have our strategy. Yes, there's the mandate. We are custodians of the intellectual property, and there's a mandate from nationally that we need to protect and ensure that it's commercialized or for the benefit of the society. But as long as it's protected, we'll take care of you, unless otherwise. But if it's a situation whereby what to protect, what to not to protect, it has to be aligned with our strategy. We can't protect everything because we don't have enough resources to protect everything. And of course, it must speak to the market, it must speak to the strategy, and it might have an impact. I hope I've answered you. Thank you. Divine?
Okay, thank you, Lundo. Yes, so I'm from the University of Zambia, where I'm sitting in the TTO as acting manager. We are currently operationalizing the office of the TTO. We just started setting it up as of last year. So actually, if there will be any form of support that comes in terms of capacity building from such programs, I think the institution is going out there looking for that. So I have a question, Lundu, from your experience. Currently, we are undertaking technology surveys where we're doing an audit to find out, we are an institution that has done a lot of research, but we say most of it is fragmented in that we didn't have this new view of research and innovation. We've just set up the Office of the Deputy Vice Chancellor, Research and Innovation as of last year. So it's in operation right now. One of the things I would want to get from you, how do we now move as we are operationalizing to tap into the rich research that we have as an institution? How do we convince researchers to move from the traditional way of publishing to now looking at securing IPs in terms of the value of commercialization? What strategies are you using? What sort of incentives do you have that easily convinces the traditional way of doing things as a university into moving now into the entrepreneurship and the commercialization route? Thank you.
Okay, I think the first thing we'll be looking at the university policy and the strategy. That what does the university see itself? Because yes, you might have this mandate that, okay, you need to file patents or protect, because I think certain institutions, even in my country, had that issue, that problem, that when the act came into practice, everybody was under pressure to protect IPs, in so much that we've got certain IPs gathering dust, not going to the market. So I think now, learning from other institutions, as you indicated, that you actually done a survey, technology survey, and see the type of research that you do, it's also important to benchmark. You look at the university strategy and the policy. Where does the university see itself? What are the niche areas or thematic areas? What type of funding would you attract? Because if you are depending on government, there are limited resources. So what type of research you're doing and the industry collaborations that you have, and that will align, because alignment is very important. So in our case, we have those awards. When we do institutional awards, we used to have research awards that were focusing only on publications. And now coming up with institutional awards, looking at other elements of research, applied research, community engagement, entrepreneurship. There are awards. They might be non-monetary, some of them, but there are awards that are monetary that, okay, if you came up with this award for IP creators, that, okay, you're going to get a recognition, you're going to get promotion if you've actually filed a patent. It might not be granted, but there are those that are promising. So we've got that strategy that, okay, for promising, for those that are promising or potential IP, which is still on the first stage, what do? We give, there's a certain award for that. And for those who are granted, and for those who are collaborating with industry. And of course, we don't expect researchers to go to the industry. We form those networks. But of course, it might be different on the technology that you are having, that maybe we don't have that such funding or that network. So the important thing is alignment with the strategy, because you can't be having something that is speaking against your university policy. Yes, the national policy is there to guide, but what do you stand for as the University of Zambia? If you are in Zambia, what do we know Zambia for? If I'm at Durban University of Technology, what am I known for? If I'm at UKZN, what is it that I'm known for? So that is very important. So it's not one size fits all. You look at the policy and what you stand for and what you can offer. What is the other thing that is important is incentives. So you incentivize. So incentive, it might not be, you might not have enough resources in terms of money, but in terms of promotion that, okay, yes, you published, I don't know the policy in your country, but in South Africa, if you publish, there's a unit. I think one unit, if you are publishing in a journal, accredited journal, it's about 120 something thousand. So now what the policy does, the institutional policy does say, okay, you get this much as a researcher. And then a certain amount goes to a research account, and then a certain amount goes to the university. So you can come up with such incentives that, okay, if you publish and then provided that you filed a patent, you protected a patent, we're going to add more money in your research account. So that would be in my view, it's the incentive, and of course, the other incentives, that is promotion if you get an IP, and awards, which is recognition that you are contributing in the economic benefit of this country or for social impact. Any other questions? I hope I've answered you, sir, Divine. You are muted, sir, Divine.
Yes, no, that has been answered. Thank you very much,
Thank you.
guiding.
Okay. Okay, and there's another one. Okay, there's a comment from Kutsia that is at MDMSA, Medical Device Manufacturers of South Africa, and NPC, which is a nonprofit organization. We are working to build a bridge between academic innovation and commercialization. The objective is leveraging of the existing manufacturing and regulatory compliance of our members. We'll also consider that because, yeah. So I just hope even other participants, because I think here more than that we sharing or trying to take you through step by step, it's also will draw from your insight as coming from Technology Transfer Office. That's what will be the best coordinated approach, taking research into transferring it to a market. So what would be the best pathway to do that, to commercialization, instead of research sitting in shops or gathering dust? I think from my side, that will be all if there are no further questions. Over to you, Rosemary. Thank you.
Big thanks to all of you. That's a very last chance for any questions to any of the presenters or to us at the project. You're also welcome to place further questions on the evaluation form. We have some fields that allow you to make suggestions, and if any questions arise after the presentations or anything you feel hasn't been answered, you can also ask questions that we'll pass on to the presenters. We also mentioned yesterday the IP Help Desk, the AEIP Project IP Help Desk, which allows you to put questions that will go to experts in Europe and Africa to answer as appropriate. So you can take advantage of that as well. And the various other opportunities, as Surima will be offering other training in the course of the year and the first half of next year. So keep an eye open. We're also asking you if there are particular topics you'd like covered. We can try and build that into our schedule. We've posted the links to the evaluation form a few times. So if you page up the chat, you'll find that, and we encourage you to complete those, particularly if you want an attendance certificate, which you'll request via the evaluation form. These are important to help us improve our offerings to you and make sure that it's meeting your needs. To our two presenters, an enormous thank you. You both did a great job from your respective perspectives, and really, really appreciate the time and effort that you put into this, Nikki and Patrick. And to the rest of you, thanks for really engaging discussion. I certainly really enjoyed the different perspectives that were represented here. So with that, I think wishing everyone a good weekend, and we can say goodbye. Thank you.
Thanks all.
Thank you, Rosemary. Thank you, everyone.
Thank you. Bye.
Bye.
Thank you. Bye.
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 Thank you very much. Lovely weekend too.
You too. Bye.
Bye. Bye.
Bye.
Bye.
Bye. Au revoir. Au revoir à tout le monde.